A guten Erev Shabbos. How are you, my holy sisters and brothers? It's also an Erev Rosh Chodesh. Tomorrow, or beginning tonight with Shabbos, it's Rosh Chodesh. This Shabbos is the last day of the month of Av, and on Sunday, it's the first day of the month of Elul, right? So the last Hebrew month of the year is Elul. And we enter Rosh Chodesh Shabbos, so the last day of the previous month, but it's a 2-day Rosh Chodesh. So anyway, this Shabbos and Sunday, we're celebrating the beginning of Elul, Rosh Chodesh Elul. That's a wonderful time of year. Sunday morning, we begin blowing the shofar every day throughout this whole month of Elul as we anticipate Rosh Hashanah 1 month away. But today, let's focus on our learning as Shabbos is approaching. Let's light up the darkness. Who is with us? Oh, I did it again. I need to share the show when Nina's not here. Yikes. All right. I'll be welcoming people in one moment. So first, I have to switch. Gosh. Okay, so I have to switch this to accidental Talmudist account, and then I can share it into the places where I need to share it. I hope you're all good. Please forgive me. I should have done this sharing during the timer countdown, but we're getting there. I really miss Nina. I can't function without her. But they're having a wonderful time delivering our daughter to college. Can't believe how fast that went. You know, we knew when we started raising kids that it would go fast, and it did. And it did. One last one, and then I'm all yours. This one. Okay. Right. Okay. Welcoming everybody now. Go click on that. Okay, Yehuda. Saying Shabbat Shalom, Nina, Sal, and everyone from Florence, South Carolina, wishing all a restful and rejuvenating Shabbos. And I'm so glad you're here, Yehuda, because you are the sponsor of today's episode of AT Daily. This is number 965. You know, we're not that far away from the 1000th episode. Yehuda is sponsoring our learning today, dedicating it to her dear mother's refuah shlema, her complete healing. So we dedicate today our learning to Miriam Bas Sarah, who is battling an illness. May Hashem heal her and all Israel. A beautiful dedication, Yehuda. We say amen to that. Please, God, grant the refuah shlema to Miriam Bas Sarah and all Israel. And Yehudis, may you and all your loved ones be showered in blessings. Thank you for sponsoring our show and enabling us to share more Torah with more people around the world. We say amen. Nancy with us, John in Maine, Rachel says Shabbat Shalom, Tom in PA, Lewis in California, Paula in the great Northwest, Gordo checking in from Scotland, Paula saying Shabbat Shalom, Tom, Chodesh Tov, Patrice in Utah, Devin says Shabbat Shalom, Clarice in Mexico City, Tom, Toda Rabah, Yehuda says, Amen. Toda Rabba. Amen. Gail finally gets to see us live. So glad you're here. We're on the YouTube side. Marjorie checking in from Virginia. Welcome, everybody. Okay. Today's daf. Nun Aleph, page 51 here in Tractate Kesubos, the 15th volume of the Talmud. These are the laws, generally speaking, of marital contracts, marriage contracts, and we are on page 51 covering Mishnah number 7, finishing our discussion of Mishnah number 6 and beginning Mishnah number 7 here in chapter 4. And we're getting more directly into the rights and obligations of the spouses that are spelled out in the marriage contract. We picked this up on 51a. We got a little head start yesterday, so we're near the top of 51a. The sages taught with regard to both property that has a guarantee, i.e. real estate, and property that does not have a guarantee, movable objects, the court removes them from the orphan heirs for the sustenance of the wife and for the daughters. Now, so how do we get into this area of the law? We hear about property liens. It sounds like, ooh, that's really technical. That's, lawyers and realtors. But really, it's not that complicated. The basic stipulation of the kesuba, of the marriage contract, is that the woman who's getting married, if the husband should divorce her or if he should die, he's going to owe her money, right? And if she was a virgin when she entered the marriage, it's 200 dinars. And if she was a widow or a divorcee, a non-virgin, it would be 100 dinars. That's the minimum amount that the husband would owe her when the marriage ends. But of course, they may have stipulated that the spouses may have agreed to a much larger amount. She came from a prominent family, and perhaps he did too. And then, the families wouldn't agree to this wedding, to this marriage, unless he promised a much larger amount. Now, these amounts that he's going to owe her, they need to be guaranteed by property. And as we've seen before, certainly that minimum amount that the wife is owed, all of the husband's property is subject to a lien in order to pay off that amount when the marriage ends. Even if he liquidated all his property, because the wife has an absolute right to that payment, at least that minimum payment, they would even go and pursue property that he had sold and then, wasted the money. And they might even actually go to the buyer of that property and withdraw some of it in order to pay off the wife's marriage contract, right? If I can't sell your property to someone else, right? It's your property. I have no right to sell your property. That would be stealing. Well, if your property was being used to guarantee a loan for someone else or to guarantee a payment that would be owed, then, the one who is the beneficiary of that guarantee, in a sense, owns that property, and you don't have an absolute right to sell even your own property, and that's what it means that there's a lien on it, okay? So with regard to both property that has a guarantee, right, usually real estate is what has a lien on it, and property that does not have a guarantee, like movable objects, the court removes them from the orphan heirs for the sustenance of the wife and for the daughter. So in that patriarchal system that existed at the time the Torah was written, and even at the time of the Talmud 1,000 years later, more or less, it was very patriarchal, and so it was the males who would inherit their father, right? So the girls did not inherit from their father unless there were no boys in the family. Then they do inherit. But it's technically, the boys are the inheritors, and the oldest boy gets the double portion. However, the female offspring, right, the daughters and the widow have this right to be sustained, right? And their right to be sustained will sometimes trump the right of the heirs, right? Because if somebody's going to have to go out begging, better it's the boys than the girls, as we've seen before. So this is the statement of Rabbi Yehuda Hanasi. Rabbi Shimon ben Elazar says, with regard to property that has a guarantee, the court removes it from the possession of the sons, who are the heirs, for the sake of the sustenance of the daughters. if the deceased father had only daughters and the adult daughters have taken possession of the estate. So then the court takes some of the property from the adult daughters in order to give an equal share to the young daughters. And likewise, one takes some of the property from the adult sons in order to give an equal share to the younger sons. And in a case where the estate has a large amount of property so that there is more than enough to provide sustenance for the daughters, the court takes from the daughters the property that is not needed to provide for their sustenance and gives it to the sons, who are the true heirs. However, in a case where the estate has a small amount of property, one does not take it from the daughters in order to give it to the sons. By contrast, with regard to property that does not have a guarantee, i.e. movable property, the court removes some of it from the possession of the adult sons, if they had taken it, in order to give their fair share to the young sons. And similarly, some property is taken from the adult daughters in order to give fair share to the young daughters. And if there are both sons and daughters, and the daughters have seized the movable property, it is taken from the daughters, who are not entitled to sustenance from movable property, and is given to the sons, who are the heirs. However, they do not take any property from the sons in order to give it to the daughters. And the Gemara comments, even though we maintain in general that the law is in accordance with the opinion of Rabbi Yehuda Hanasi in disputes with his colleague, and therefore the law should follow his ruling rather than that of Rabbi Shimon ben Elazar, here the law is in accordance with the opinion of Rabbi Shimon ben Elazar. As Rabbi said, the law is that a woman can collect her claim from land, but not from movable property, whether for the marriage contract, for sustenance, or for her livelihood. That would seem to be the final word, right? That the woman, the wife in a marriage, or the daughters, has this lien on the property so that they can receive their sustenance, livelihood, whatever they need, but it is only on real property, right? Real estate, land, not on movable property, contrary to the opinion of Rabbi Yehuda Hanasi, and it was very clear here in the Gemara that that's the final word. These women can collect from real property and not from movable property. But, not so fast. What is the law on this? Where did the law end up? What is the halacha? According to the original rabbinic enactment, the sum specified in a marriage contract can be collected only from land. However, the Geonim instituted that it can be claimed even from movable property because in their time, most people did not possess land and relied instead on movable objects. Who are the Geonim? Right, so you have, if you sort of look at the history of the sages and rabbinic Judaism, so the earliest stage of the rabbis, who are ruling on Torah law, are called the Zugot, the pairs, right? So like Hillel and Shammai, who were ruling and teaching even while the temple was standing, the second temple. Then you have the Tanaim, right? These are the rabbis of the Mishnah, sort of from the end of the second temple period until about the year 200. Then you have the Amoraim, right? These are the rabbis of the Gemara from about the year 200 to the year 500 of the Common Era. Then there's a kind of in-between area, the Savaranim, but we don't often use that term. Really, the next group are called the Geonim. Right, so these are the early rabbis and commentators who come after the Talmud has closed, as it were. They're the next stage of commentary and interpretation on the Talmud after the Talmud itself has closed, after the Gemara has been completed around the year 500. So the Geonim, right, they're active about from the year 500, 600 to about 1000 or 1100, right? And Rashi's at the tail end of that. So these are the commentators, this is like the Rabbi Gershon, who said that a Jewish man cannot have two wives. He was one of the Geonim around the year 1000. And so they said, well, look, these laws were created and even ruled on at a time when in Israel and in Babylonia, the Jews were generally landowners And so if a wife, a widow, an inheritor, a daughter was going to look to land for her, to get what she is entitled to, what she's owed under the laws of marriage contracts and sustenance for women and for daughters and widows, etc., there would be land to pursue. But as the Jews as our fortunes fell lower and lower, and we were exiled to other lands, and in some of these other lands we were not allowed to own property, and Jews became much more merchants than landowners because of those laws and the persecution of Jews in many countries around the world. So if you could only, take these kinds of inheritances and payments from land, but the Jews own no land, it really wasn't helping the widows and the daughters. And so the Geonim changed that law in order to protect the daughters and wives of the Jewish people. And so we see they can seize movable property in order to fulfill these needs. In terms of the commentators, after the Geonim come the Rishonim, right? So Rambam, Maimonides, he's going to be part of that group from about 1100 until about 1600. And then the last group, sort of the commentator, which includes today's modern, prominent rabbis and commentators, are the Acharonim, right? So the later ones, the ones that come after. Okay. So that's how the law was changed, and that concludes our discussion of Mishnah number 6. Mishnah number 7 here in chapter 4. If a husband did not write a marriage contract for his wife, a virgin collects 200 dinars and a widow 100 dinars upon divorce or the husband's death, because it is a stipulation of the court that a wife is entitled to these amounts. Not only was that the minimum amount allowable in a marriage contract, but if you wrote no marriage contract at all, it's assumed that you did write a marriage contract for that minimum amount. Even if there was no contract, she's entitled to that payment when the marriage ends. If he, the husband, if he wrote in her marriage contract that she is entitled to a field worth 100 dinars, instead of the 200 dinars to which she is actually entitled, and he did not additionally write for her, all property I have shall serve as a guarantee for the payment of your marriage contract, he is nevertheless obligated to pay the full 200 dinars, and he cannot say that she should take only a mortgaged field for payment of her marriage contract, as it is a stipulation of the court that all of his property is held as surety for the entire sum. Right? So a Jewish woman who marries a Jewish man is entitled to that minimum amount, either 100 dinars or 200 dinars, under all circumstances. She can't consent to not be entitled to that. Even if she says, no, I don't have to have it, she gets it, right? That's the minimum marriage settlement, kind of a safety net for all wives. It cannot be contracted away. No, and moreover, her right to seize property, or the court to seize property on her behalf from the husband's estate or from his property, is an absolute right. She can't give that away either. Similarly, if the husband did not write for her in the marriage contract, if you are taken captive, I will redeem you and restore you to me as a wife. And in the case of a priestess, i.e. the wife of a priest, of a kohen, who is prohibited to return to her husband if she has intercourse with another man, even if she is raped and it's not her fault, still she's prohibited to a kohen. But if he did not write, I will return you to your native province, he is nevertheless obligated to do so, as it is a stipulation of the court. All Jewish husbands are obligated to redeem their wives from captivity, even in the case of a kohen, where if his wife was taken captive, it's assumed that she was raped, and therefore she would not be permitted to him when she returns. It's no fault of her own. But a kohen cannot be married to a woman that has had sex with any other man, even if it was through rape. As opposed to all other Jews, if your wife is raped, it doesn't affect the marriage. It wasn't her fault, and she's permitted back to her husband, but not in the case of a kohen. Nonetheless, the obligation to redeem her from captivity, even though it won't restore her to you as a wife if you're a priest, is an absolute obligation, whether you wrote it into the marriage contract or not. If a woman was taken captive, her husband is obligated to redeem her. And if he said, I hereby give my wife her bill of divorce and the payment of her marriage contract, and let her redeem herself, he is not permitted to do this, as he already obligated himself to redeem her when he wrote the marriage contract. If his wife was struck with illness, he is obligated to heal her, i.e. to pay for her medical expenses. In this case, however, if he said, I hereby give my wife her bill of divorce and the payment of her marriage contract, and let her pay her own medical expenses with it, he is permitted to do this. And the Gemara will discuss why that difference between he cannot divorce his wife who is taken captive and let her use the marriage settlement to pay her ransom, but he may divorce his wife who is ill and let her use her marriage settlement to pay the medical expenses. Why? We'll see. That's Mishnah number 7, Gemara. The Gemara asks, who is the author of the Mishnah? It is Rabbi Meir, who said anyone who decreases the sum guaranteed to a virgin in her marriage contract to less than 200 dinars, or the sum guaranteed to a widow, and reduced, which is 100 dinars, and he reduces it to less than 100 dinars, and then he proceeds to live with his wife, this is licentious sexual intercourse. These sums are fixed by the sages, and a husband is not permitted to pledge less than the established sum. So if he sort of made some kind of condition with his wife and his prospective wife and said, listen, I'm not into this minimum payment, I'm very poor, whatever, so I will only marry you on condition that you accept a smaller marriage settlement than the 100 dinars, for example, and she says, okay, I'll do it, and then they get together as husband and wife. Rabbi Meir is saying they're not really husband and wife. They're just living together in sin because, if they agreed to a marriage, which is not a marriage, because they agreed to this condition, which is not permitted in any case, it's like they're just living together without getting married. For if you say that this mission is in accordance with the opinion of Rabbi Yehuda, didn't he say that if the husband wants, he may write a document as a marriage contract for a virgin in which he pledges 200 dinars, and then she may immediately write, I have received from you 100 dinars, thereby waiving her rights to half the sum, so that in practice, she gets only 100 dinars. It would seem that Rabbi Yehuda allows her to agree to a smaller settlement than she's entitled to, smaller than the minimum. And similarly, says Rabbi Yehuda, he may pledge 100 dinars in the marriage contract of a widow, and then she may write, I have received from you 50 dinars. But this is not in accordance with the Mishnah, which indicates that he cannot give her less than the minimum amount, even with her consent. Now, the Gemara raises a difficulty. But now say the latter clause of the Mishnah. If he wrote in her marriage contract that she is entitled to a field worth 100 dinars instead of the 200 dinars to which she is actually entitled, and he did not additionally write for her, all property I have shall serve as a guarantee for the payment of your marriage contract, he is nevertheless obligated to pay the full 200 dinars, as it is a stipulation of the court that all his property is held as surety for the entire sum. In this clause, we have come to the opinion of Rabbi Yehuda, who said that omission of the guarantee from a document is presumed to be a scribal error, unless the document explicitly states that the property of the individual who wrote the document is not liened to guarantee the transaction. For if this is the opinion of Rabbi Meir, didn't he say that omission of the guarantee from a document is not a scribal error, i.e., a lien can be placed on the property to guarantee the transaction only if the document explicitly states this to be the case. And the Gemara cites the source of this dispute, as we learned in the Mishnah. Right? So here it seems like we have a dispute on marriage contracts between Rabbi Meir and Rabbi Yehuda, where Rabbi Meir says, under no circumstances can a husband lower the value of the marriage contract to less than the minimum amount, and even if the wife agrees to it, they haven't agreed to anything. Rabbi Yehuda says if they agree to it, they can make it less than the minimum amount. Elsewhere, there's a different dispute between Rabbi Yehuda and Rabbi Meir about people who engage in a transaction And if it's the sort of transaction where normally it is guaranteed by a lien on real property, like for example, you sell somebody a field, but they don't give you the full purchase price right away. They're going to pay it off over time. That would seem to be guaranteed by the land itself, or a right to produce or something like that. So in a situation where there's normally a lien, and they didn't write into the contract that there is a lien, Rabbi Meir says, Rabbi Yehuda says it's a scribal error. They meant to include the lien, but they forgot to include it in the contract, so it must be that the lien is valid. And Rabbi Meir would say it might be a situation where there's normally a lien, but they wrote a contract, they didn't include the lien in the contract, so there is no lien. We don't assume that it's a scribal error. That's in other kinds of contracts. And you might say, well, why wouldn't they have the consistent position between the way they talk about those contracts and the way they talk about marriage contracts? And probably the answer is going to be, well, marriage contracts are different than other kinds of contracts because we want to protect the wife from being stranded. Okay. As we learned in the Mishnah at Bava Metzia 12b, with regard to one who found promissory notes, okay? So now, the way they're going to get at this is through a different case. What's a promissory note? It's a contract that is evidence of a loan, right? You lent me money. I promise to pay it back. My promise is evidenced in this promissory note. You, as the lender, are going to hold the promissory note, and you're going to come bring it to me and say, hey, Sal, you owe me money. Here's the promissory note. Pay up. Right? And you could theoretically sell the promissory note. It's like selling a security. Sal owes $20. You're tired of waiting for it. Maybe you'll sell that note for $15 to somebody else who will come to me and say, hey, give me the 20 that this promissory note evidences. Okay, that's a promissory note. Now, what if you're walking down the street and you find a promissory note on the ground? Now, you might think, well, whoever's bearing this note can go collect the money. Maybe yes, maybe no. Maybe it's a promissory note for a debt that's already been paid. And they should have ripped up the promissory note, but they didn't. So now that you found it, what are you going to do with it? You have an obligation to return lost objects. Who are you going to return it to? Are you going to return it to the borrower or to the lender? Presumably you would return it to the lender. But there's a problem. As we learned in a Mishnah, with regard to one who found promissory notes, if the promissory notes include a property guarantee, he may not return them to the lender, as the finder does not know who lost them. It is possible that the debt has already been paid, and the documents were returned to the borrower, and he lost them. So the finder may not give them back to the lender, even if the borrower admits that he still owes the money. Why? As the court collects the debt from purchasers of the borrower's property, there is a concern that the borrower has repaid the loan, and he is saying that he did not yet repay it because he is conspiring with the lender to convince the court to confiscate liened property that the borrower sold, and the lender and borrower will divide the proceeds, right? They might be conspiring. You lent me some money. I promise to pay it back. As a guarantee that I will pay it back, you have a lien on a field that I own. Let's say I paid you back. Okay, we're done. But if I paid you back and at some other point I had that field and I sold it, right? I sold it to someone else. I got some money for that. And maybe I used the proceeds of that sale to pay you back. But now you and I are going to conspire and we're going to say, you know what? I didn't pay back. I haven't paid back. Therefore, you have a right to that field, which served as the guarantee for the loan. Now, I sold that field, but I didn't have a right to sell a field that you have a lien on it. So if we're conspiring liars, you can now go to the purchaser of that field and say, hey, you thought you were purchasing a field clear and, with free and clear title, but you were misled. I have a right to that field. It guaranteed a loan. That loan hasn't been paid. I'm going to get that field. And he can go to court to get it. So if you and I are conspiring to rip off that sucker who purchased the field, we could get away with that maybe. We should be penalized heavily when we get caught. But to guard against such an outcome, if somebody finds promissory notes, he's not allowed to just give it to the lender. He's going to have to be more careful than that. If, however, these promissory notes that you find on the street were of the kind that do not include a property guarantee, there is no lien on a field somewhere, then the finder can just return them. As in this case, the court does not collect from purchasers of the borrower's property. And this is the statement of Rabbi Meir. And the rabbis say, in both this case and that one, he may not return the promissory notes, as the court collects from purchasers of the borrower's property, regardless, as it is assumed that the omission of the property guarantee from a document is merely a scribal error. It would seem that the custom was that any time there was a promissory note, if the borrower owned land, then his land would serve as a guarantee for the money that he was borrowing, even if that was not mentioned in the contract. If so, the first clause of the Mishnah here is in accordance with the opinion of Rabbi Meir, and the latter clause is in accordance with the opinion of Rabbi Yehuda. And if you would say that the entire Mishnah is in accordance with the opinion of Rabbi Meir, and there is a difference for Rabbi Meir between marriage contracts and other documents, i.e. the guarantee of a marriage contract applies even if it is omitted, but the property guarantee in other contracts does not, is there really a difference for him between the two types of documents? Isn't it taught, and by the way, we're on 51b, isn't it taught in a Baraisa 5 claims may be collected only from free assets, and there, meaning not land, may be collected only from free assets, and they are as followed: produce and enhancement to the produce, and likewise in the case of one who accepts upon himself the duty to sustain his wife's son or his wife's daughter, and then he dies. They receive their support only from the estate's free assets. And other claims that may be collected only from free assets are document of debt that does not include a property guarantee, and the marriage contract of a wife that does not include the property guarantee. Whoa, whoa, whoa. We thought that a marriage contract automatically includes a property guarantee, even if it doesn't say so. That's what our Mishnah is teaching. Now the Gemara reasons, whom have you heard say that omission of the property guarantee from a document is not a scribal error? Rabbi Meir. And yet the Baraisa teaches that the same applies to the marriage contract of a wife. And this proves that according to Rabbi Meir, there is no difference between a marriage contract and other documents. And the Gemara answers, if you wish, say that the Mishnah here is in accordance with the opinion of Rabbi Meir, and if you wish, say that it is in accordance with the opinion of Rabbi Yehuda. And the Gemara explains, if you wish, say that the Mishnah is in accordance with the opinion of Rabbi Yehuda, and there, in the other Mishnah on page 54b, the case is where she wrote to him, I have received it, thereby waiving her right to part of the marriage contract. Not that she's waiving her right to the guarantee, she's waiving her right to receive the money at all because she's saying she already received it. In contrast, here, she did not write to him, I have received it, and therefore she collects the entire sum from him, even if he did not write a marriage contract. And conversely, if you wish, say that the Mishnah is in accordance with the opinion of Rabbi Meir. According to this interpretation, what is the meaning of the phrase, he is obligated, which is taught in the latter clause of the Mishnah with regard to the case where the marriage contract did not specify that the husband's property will serve as a guarantee of his obligations toward his wife? It means that the wife's claims may be collected only from the husband's free assets, i.e. she does not have a lien on his real property. The Mishnah taught that if the husband did not write for her, that he would redeem her from captivity. So that's it. That's as much as they're going to say about liens. But the bottom line is a wife has a lien on the real property and the movable assets, which was the later addition of the Geonim, in order to have her marriage contract paid. New subject. The Mishnah taught that if the husband did not write for her, that he would redeem her from captivity and restore her to him. He is nevertheless obligated to do so, as this is a stipulation of the court. Now, Shmuel's father said, Shmuel the sage in Bavel, the wife of an Israelite who was raped is forbidden to her husband, as we are concerned that perhaps her ordeal started as rape and ended willingly, i.e., during the act she may have acquiesced, and a married woman who willingly had relations with another man is forbidden to her husband. Let's understand what he just said. So this poor woman, she's married. She gets kidnapped by a marauding army. There's an assumption that armies who kidnap women would rape the women. She's the wife of a Yisrael as opposed to a kohen, right? So if a kohen's wife is raped, they're going to have to get a divorce because he cannot be married to a woman who had sex with another man. That's just a law for kohanim, right? Just for the kohens. But every other Jew, if his wife gets raped, it's tragic. But when the ordeal is over, she gets back with her husband. Shmuel is saying that she was kidnapped by the marauding army, she was raped by the marauding army, and because she was held by the marauding army for, who knows how many months, it's possible that after a while she, stopped resisting and was willingly sleeping with her captor. And because that might have happened, this woman is going to be prohibited to return to her husband. Is the law like Shmuel's father? No, it is not. Shmuel's father gets overridden. Rav raised an objection to the opinion of Shmuel's father from the Mishnah, which states that one of the stipulations of the marriage contract reads, "If you are taken captive, I will redeem you and restore you to me as a wife." And this indicates that despite the possibility that she might have been raped during captivity, she remains permitted to her husband if he is not a priest, and there is no concern that she might have ultimately agreed to the act. Shmuel's father was silent, and he did not respond. Rav recited the following verse about Shmuel's father. The princes refrained from talking and laid a hand upon their mouths. Job 29:9. The Gemara comments, the application of the verse to Shmuel's father indicates that he refrained from responding despite the fact that an answer was available. But what is there to say for him? What could he have said? And the Gemara answers, well, he could have said that in the case of a captive woman, they were lenient. Since it is uncertain whether she was in fact raped during her captivity, the sages were lenient. However, it is possible that they were more stringent in the case of a woman who was definitely raped, since there's a double uncertainty. She was simply taken captive. They don't know for sure that she was raped, and they certainly don't know for sure that if she was raped, and she was raped repeatedly, that she eventually became, a willing partner to her captor. That's two uncertainties. But you might have said, well, if it's known that her captors raped her, then there's no uncertainty about that. And then perhaps the uncertainty that she might have become a willing participant will cause her to be prohibited to her husband. He could have said that. He remained silent, and he was wise to remain silent because we're not concerned about that. And the Gemara further asks, according to Shmuel's father, how can you find a case of rape where the merciful one permits the victim to remain married to her husband? It is always possible that a rape victim might have ultimately acquiesced, and the Gemara answers, for example, where witnesses say that she screamed continuously from beginning to end. And so Shmuel's father going to say that unless there were witnesses who heard her screaming from beginning to end, we're concerned that she acquiesced and she's going to become prohibited to her husband? No, we are not. And the Gemara comments, and Shmuel's father disagrees with the opinion of Rava, and Rava's opinion became the law. As Rava said, with regard to any case that starts as rape and ends willingly, even if she ultimately says, leave him alone, leave my rapist alone. And she further states that if he had not forcibly initiated intercourse with her, she would have hired him for intercourse. Even in that case, she is nevertheless permitted to her husband. And what is the reason for this? Because the evil inclination took hold of her during the act, and therefore she is still considered to have engaged in intercourse against her will. No means no, and no means no both today and tomorrow. Even if it was some kind of Stokholm Syndrome, that they captured her, they raped her, and they held her against her will for an extended amount of time, so that after a while, she was manipulated into becoming a sort of, willing participant. No, she never would have been in that situation if she had not been captured and raped in the first place. And so according to Rava, no matter what happens afterward, we consider that she never willingly acquiesced, and she will always remain permitted to her husband when she gets back and gets away from that. And as we're reading about this, I was reminded, some of you are maybe old enough to remember in the 70s, the case of Patty Hearst, right? Patty Hearst was the granddaughter of William Randolph Hearst, a very, very rich heiress who was kidnapped by American terrorists, right? I think they were American, maybe there was something else, the Symbionese Liberation Army, whatever they were. And they were robbing banks, right? And so she was kidnapped against her will. She was raped against her will. She was held for many months, and then eventually she was cited participating in their bank robberies. And when they were finally all caught and she came to trial, very much the testimony was that she was brainwashed, she was manipulated, it was all against her will, even though eventually she sort of participated voluntarily. And tragically, the court did not believe her, and she was actually sentenced to 35 years in prison. That was later commuted to 7 years in prison. And then she was, I think, released even early from that by Jimmy Carter. And then Bill Clinton pardoned her entirely. But it's that same idea: captured, raped, her mind manipulated. And under Jewish law, she would have had no issue because she was not responsible for what happened later. Now, it is taught in a Baraisa in accordance with the opinion of Rava. The verse states with regard to a sota, right? So the suspected adulteress, and a man lies with her and she was not taken. And this is referring to a woman who had intercourse but was not taken forcefully, i.e. she was not raped, and therefore she becomes forbidden to her husband. And from this it may be inferred that if she was taken forcefully, she remains permitted to her husband. And the word she teaches that you have a case of another woman where even though she was not taken forcefully, she remains permitted to her husband. And which case is this? This is any case that starts as a rape and ends willingly. Although at the conclusion of the act, she was not taken forcefully, she is nevertheless permitted to her husband, as stated by Rava, because this whole sequence of events began with a capture and a rape against her will. A different inference from the same verse is taught in a different Baraisa, and she was not taken. In this case, the woman is forbidden to her husband. It may be inferred that if she was taken forcefully, she remains permitted to her husband. And you have another case where even though she was taken forcefully, she is forbidden to her husband. In which case is this? This is the case of the wife of a priest. Even though she did not acquiesce in any way, a priest cannot remain married to a woman who had sex with another man. At least not and continue serving as a priest. The courts would, in that case, sort of force them to divorce at certain times in history. But at other times, I think they would just leave them alone and he could make that choice for himself, even though he would be a disqualified kohen. Rav Yehuda said, another exposition of this same verse, that Shmuel said in the name of Rabbi Yishmael. And she was not taken. In this case, she is forbidden to her husband. It may be inferred that if she was taken forcefully, she is permitted to her husband. And there is another case, and there is a case of another woman where, even though she was not taken forcefully, she nevertheless remains permitted. In which case is this? This is referring to one whose betrothal was a mistaken betrothal. As even if her son from this marriage is riding on her shoulders, she may refuse to remain with her husband and go off as pleases her. Since she was not really married to begin with, an act of intercourse with another man does not render her forbidden to the man with whom she performed a mistaken betrothal, right? So if you are married, a married woman who commits adultery, a Jewish woman married to a Jewish man who has sex with another Jewish man who's not her husband, this is adultery. That is a death penalty offense. But if her marriage is not a real marriage because there was a mistaken betrothal, well, then any act of sex that she has with some other partner is not adultery because she's not cheating on her husband since she doesn't actually have a husband. Now, Rav Yehuda said, those women stolen by kidnappers are permitted to their husbands, as even if they had intercourse with their captors, it is considered rape. And the rabbi said to Rav Yehuda, but while they are captives, they bring their kidnappers bread. And this indicates that they are not acting under duress. And he replied, they do so due to fear. Think Patty Hearst. The rabbis further inquired, but they send them arrows. And Rabbi Yehuda again replied, this too is due to fear. However, I certainly agree that if the kidnappers leave them alone and they go back to them of their own accord, they are forbidden to their husbands as it is clear that they are no longer acting out of fear. So if the chance to escape and return to their husbands and they don't take it, then maybe you could make that argument. But I think there would also be plenty of testimony they could receive at that point that she's been so manipulated that, even though she was technically, physically free to leave, she might not have felt that way after all she's been through. The sages taught with regard to women captured by the monarchy for the purpose of having intercourse with the king, they are considered to be like captives, i.e. they are assumed to have been raped, but not to have consented to the intercourse. However, those stolen by bandits are not considered to be like captives, as there is a concern that they might have consented to their captors, thinking that they will marry them. What? And the Gemara raises a difficulty, but isn't it taught in the Baraisa that the reverse is the case? I.e. women taken by the monarchy are not classified as captives, whereas this status does not apply to those who are abducted by bandits. I'm almost finished, so if you got questions or comments, get them in. And now they will explain what is the difference for women who are taken captive by bandits versus taken captive by the soldiers of the king. That would be like Esther in the book of Esther, right? So the women around the Persian Empire were taken so that, Achashverosh could have one night with them. And Esther ended up being the most pleasing of all those young women, and she got to marry the king. But all the rest of them, were kidnapped, had sex with the king for one night, and then ended up living in a harem very much against their will. Now, the Gemara answers, the apparent contradiction between the ruling of one Baraisa with regard to those captured by the monarchy and the ruling of the other Baraisa with regard to those captured by the monarchy, which seems to be, so are they considered that they were raped against their will or not? Well, this contradiction is not difficult. The first Baraisa is referring to the monarchy of Achashverosh, a powerful king, as the woman is aware that he is merely using her to satisfy his lust and will certainly not marry her. Whereas that other Baraisa, which thinks that she, considers that she might be acquiescing in this, is dealing with the monarchy of Ben Netzer, a man who established for himself a minor kingdom through robbery and small-scale conquests. And it is possible for a woman to suppose that a king like Ben Netzer will eventually marry her, and so that she's participating in this willingly. Similarly, the apparent contradiction between the ruling of one Baraisa with regard to those kidnapped by bandits and the ruling of the other Baraisa with regard to those kidnapped by bandits is not difficult. The first Baraisa is referring to the banditry of Ben Netzer, as she might agree to his advances, hoping to become the wife of a, little bandit king like him. Conversely, the other Baraisa is dealing with regular bandits, as it can be assumed that the women did not acquiesce to having intercourse with them, as even if he wanted to marry her, she would not agree to marry this bandit. And the Gemara asks, and this Ben Netzer, how can it be that there he is called a king, and here he is called a bandit? And the Gemara answers, yes, when considered alongside Achashverosh, he is merely a bandit. But when considered alongside standard bandits, he is deemed a king. That's the colorful story of Ben Netzer. All right. Let's see if I can scan the comments here and answer some questions. Okay. Tom, if the kohen has to divorce his raped wife, must he pay her the marriage contract? For sure. For sure he will have to pay the marriage contract. Yes. Where am I? So where it's back and forth, I'm not going to be able to read all that stuff, so I'm going to just skip that. Tom, can the husband choose to divorce his captive, raped, redeemed wife anyway, even if he isn't required to? Well, yes, because the husbands always had a right to divorce their wives, right? That was a unilateral right in a patriarchal system. So he wouldn't have to say that the reason he's divorcing her is because she was taken captive and she might have been raped or not, and she was held for a long time. That's actually irrelevant. He can divorce her for whatever reason he wants, but he will certainly have to pay the marriage contract payment if he does that. And the society that he lives in might shun him for doing such a thing. Sharon, Stockholm Syndrome, becoming in cahoots with one's captives, just so. Tom, but doesn't intercourse basically create a marriage or only after betrothal? Okay, so that seems to be a complicated question that we keep running into. So if a single Jewish man and a single Jewish woman sleep together, are they married? One answer would be yeah, because bia, right, the actual physical intercourse, is one of the processes through which people can become married. Right? There's also the kinyan, like you give her the ring, with which she, that symbolizes that, he has acquired her as a wife and now they're officially married. Or there's the writing of the marriage contract, or intercourse is a way to do that. Now, if they had no intent to get married and they performed intercourse, did they actually get married? Certainly we don't view it that way in modern times. But did it actually happen? It's sort of a case-by-case circumstance, case-by-case question. And there's other elements involved that are sort of outside the scope of this conversation. But at least according to one opinion, yeah, they did get married. And it's a problem. They need to build divorce afterward. But we don't normally rule that way. Lewis, in the case of a priest who chooses to remain with a wife who was raped, do his sons continue to be priests? Great question. So, first of all, the sons that were born before that, so from her, right, like their marriage was fine at that time, so they remain, I think they remain priests, they remain qualified priests. They're always going to be priests. The son of a priest is always a priest. The question is, are they a halal, a disqualified priest? So I think that if he chooses to remain with her, any children she has for him after that, for sure, are disqualified. So they will not be able to serve as priests. And let's say that he then dies, but she remained married to him after her rape. That's going to make her a halala. And so she's not going to be able to marry another priest. No priest would marry her after that. But I don't think that, or let's say his sons from a different wife, I don't think that they become disqualified just because he chose to remain in a marriage that was prohibited to him. I'm not sure. That's my impression, but I'm not sure. Okay, that's what I've got for us today. This was a lot of amazing learning for a Friday. With God's help, we'll be together again tomorrow night after Shabbat ends for page 52, probably about 9 p.m. Pacific. And just a reminder, no class on Sunday because I'm attending my friend's wedding. Big celebration. And then on Monday, we'll probably do the double daf to get caught up. I wish you a great, refreshing, sweet Shabbos. And Chodesh Tov, this Shabbos and Sunday, we're celebrating the new Hebrew month of Elul, the last month of the year, and we start turning our attention to Rosh Hashanah a month from now.